I'd like to take this opportunity to introduce today's presenter, Jennifer Damon. Jennifer oversees regulatory compliance and data security for AccuSource. She also manages our quality assurance processes. Jennifer has over 10 years experience in the background screening industry. She is a University of Akron School of Law graduate where she earned her Juris Doctorate degree. Jennifer is a seasoned compliance and human resources professional and has served in roles for both direct employers and consumer reporting agencies. In her tenure, she has interpreted criminal and civil record summaries, managed quality control, overseen audit processes, and managed contract review. In her regulatory compliance leadership role at AccuSource, Jennifer is responsible for review and interpretation of federal, state, and local legislative and regulatory changes, as well as managing our NAPBS accreditation and vendor audit processes. Now I turn over the presentation to Jennifer.
Good morning and welcome to the webinar. We'll be addressing a variety of topics today, and I will be answering questions at the end of the presentation. Please send any questions you may have, and I will address as many of them as possible, or will follow up through email if I do not have time to answer all questions during this time. During this webinar, we will discuss the elephant in the room that is marijuana. We may want to ignore it, but marijuana laws are multiplying, and employers must be proactive where possible to avoid potential issues. More specifically, our topics will include an overview of the states that currently have laws legalizing marijuana for medical and/or recreational use, a discussion of jurisdictions with recent or pending legislation regarding marijuana, recent judicial rulings and case law relating to employee or employer protections and employment screening for marijuana use, and issues faced by employers and jurisdictions with legalized marijuana or other laws regarding testing for marijuana. We will finish up our webinar by providing some best practice recommendations for addressing marijuana in the workplace. Before I begin my presentation, please keep in mind the following. The content provided in this presentation is for informational purposes only. It should not be construed as legal advice or serve as specific guidance. AccuSource strongly encourages current and prospective clients to seek the advice of qualified counsel, preferably specializing in employment law, prior to engaging in any legal decisions involving drug and/or background screening policies or compliance concerns. Please also keep in mind that this is a general discussion. I will not be covering specific state laws and exemptions. For example, some employers may have exemptions to the general laws due to their industry or the type of position. Some of the marijuana laws I will be discussing have carve-outs for safety-sensitive positions or those that are regulated by the Department of Transportation, as an example. It is best to discuss your specific business needs with legal counsel to ensure that you are compliant. Before we officially get started, I would like to discuss the various terms that relate to marijuana because there is a difference between cannabis, marijuana, and hemp. Cannabis is the plant itself. Both marijuana and hemp are derived from the cannabis plant. The main difference between marijuana and hemp is the amount of tetrahydrocannabinol, or THC, that it contains. Marijuana contains more than 0.3% THC, while hemp contains 0.3% or less of THC. THC is the psychoactive ingredient in cannabis that makes the user feel high. What about CBD? Its full name is cannabidiol, and it is a compound that comes from cannabis. It can contain varying levels of THC, so can be considered derived from marijuana or hemp. Now that we have discussed some basic differences between cannabis, marijuana, hemp, and CBD, we will discuss jurisdictions which have already legalized marijuana in some way, as well as some recent updates to existing laws. The United States has become much more accepting of cannabis. All but 2 states, which are Idaho and South Dakota, have legalized or decriminalized cannabis in some way. Remember that cannabis includes both marijuana and hemp, as we just discussed. Currently, 33 states and the District of Columbia authorize the use of marijuana for medical purposes. They vary from state to state, with some broader than others, especially as to the medical conditions that allow the use of marijuana. Some states only allow the use of cannabis-infused products, such as oils or pills, and do not allow the user to smoke or vape marijuana. About 15 states have protections for employees where it is unlawful for employers to discriminate on the basis of medical marijuana use. As always, there are some exceptions to these protections, but in general, there are several common protections. Off-duty medical marijuana use is protected, and employers cannot discriminate against applicants and employees for being registered cardholders or if they test positive for marijuana. There are currently 11 states: Alaska, California, Colorado, Illinois, Maine, Massachusetts, Michigan, Nevada, Oregon, Vermont, and Washington, plus the District of Columbia, that have legalized the recreational use of marijuana. Finally, some states and smaller jurisdictions have decriminalized the possession of small amounts of marijuana, which I will discuss more specifically later in this presentation. New Mexico expanded protection for applicants and employees when it amended its medical marijuana law earlier this year. As of April 4, 2019, employers cannot take adverse action against applicants or employees for conduct that is permitted under the medical marijuana statute. If an employer wants to take adverse action against an employee, it must first prove by a preponderance of the evidence that the employee's use of medical marijuana impaired his or her ability to perform his or her job. Also, employees are not permitted to use or possess marijuana in the workplace. There are some exceptions to these expanded benefits. An employer is not required to risk its monetary or licensing benefits under federal law. It can also take action against an employee who uses or is impaired by medical marijuana while at work. Finally, safety-sensitive positions are exempted from this law. New Jersey also expanded its protection, extending workplace protections to employees under the Jake Honig Compassionate Use Medical Cannabis Act, which took effect on July 2nd of this year. Employers cannot take adverse employment action against an applicant or employee based solely on his or her status as a registered qualifying patient. Additionally, employers must allow him or her an opportunity to explain a positive marijuana drug test. If the applicant or employee prefers, the employer must provide the ability to have the sample retested at his or her own cost. While an applicant or employee may provide a medical explanation for a positive result, the employer is not required to accept it. Employers are also not required to disregard positive marijuana results or permit the use or possession of marijuana during work hours. Finally, employers are not required to take any action that could violate federal law or cause it to lose licensing or a federal contract. Rhode Island also expanded its protections by enacting the Hemp Growth Act. Rhode Island employers cannot refuse to employ or otherwise penalize an applicant or employee solely for his or her status as a medical marijuana cardholder. Similar to other laws we have discussed, Rhode Island has provided exceptions. Employees cannot use or possess marijuana in the workplace or work under the influence. They also cannot operate vehicles, equipment, or firearms while under the influence. Additionally, the employer is not required to permit behavior that violates the terms of a collective bargaining agreement or risk its monetary or licensing benefits. 2019 has been a big year for marijuana legislation, which we will discuss next. First, we will review the legislation that has passed or been amended up to this point in 2019, including legislation that will go into effect soon. Hawaii, New York, and North Dakota have decriminalized marijuana, while Illinois took it further and legalized the recreational use of marijuana. New York City has banned pre-employment drug testing for marijuana, and Nevada has enacted restrictions for employers who test for marijuana. We will also discuss legislation that is upcoming, including possible federal action regarding cannabis. Several jurisdictions have decriminalized marijuana recently. While decriminalizing marijuana does not make its use for medical or recreational purposes legal, it is a step towards legalization. Hawaii had several marijuana-related bills to consider. While the governor did not legalize marijuana use, he did decriminalize it when he failed to veto the bill. Small-scale marijuana possession had previously been punished with jail time. However, after decriminalization, a Hawaiian who possesses 3 grams or less of marijuana will instead be charged with a $130 fine. New York State also decriminalized marijuana, reducing penalties for low-level possession, which is now a violation rather than a criminal offense. In addition, the state will develop a program that provides information to the public about how to expunge marijuana convictions. In fact, New York State has already begun to expunge some marijuana convictions as of early September. Those who have low-level marijuana possession records will have their records automatically expunged. North Dakota also decriminalized marijuana, passing HB 1050 with an effective date of August 1st of this year. The law reclassifies to an infraction the possession of up to half an ounce of marijuana by a person who is at least 21 years of age. There's no jail time for this class of possession, and the possessor faces up to a $1,000 fine. While these laws decriminalize marijuana, they do not require employers in Hawaii, New York, and North Dakota to accommodate its use. Illinois has joined the growing list of jurisdictions that have legalized the recreational use of marijuana. The new law, known as the Cannabis Regulation and Tax Act, and effective as of January 1st of 2020, also decriminalizes recreational use. It explicitly allows employers to maintain drug-free workplaces, conduct drug tests, and discipline or terminate employees who violate employment policies. Any discipline must be made in the good faith belief that the employee used, possessed, or was impaired by marijuana while working. It is important to note that while the law includes symptoms that may support a claim of marijuana impairment, the list does not include a positive drug test. It's likely because there's currently no test that proves real-time marijuana impairment, which we'll discuss later during this presentation. Employers must also provide a reasonable opportunity for the employee to contest its findings and cannot take disciplinary action if marijuana was used lawfully outside of work. Similar to other laws we have seen, employers are not required to violate federal law or place any government contracts at risk. In addition to legalizing recreational marijuana, Illinois also updated its medical marijuana law. The August 2019 changes are effective immediately and officially make the pilot medical marijuana program permanent. The amendment expanded medical conditions that qualify for the program, adding 12 new conditions. A wider range of medical professionals can now certify eligibility for medical marijuana, including physicians, advanced practice registered nurses, and licensed physician assistants. The updates also provide additional protection to medical marijuana users. Employers cannot discriminate against cardholders unless accommodating them would violate federal law, such as DOT regulations or the Drug-Free Workplace Act. Similar to the new recreational marijuana law, if an employer takes action against a registered medical marijuana user based on impairment at work, the employer must give the employee an opportunity to contest the determination. Whenever there's a new trend, New York City tends to be at the center of it, and marijuana is no exception. Effective on May 10, 2020, Intro 1445A prohibits New York City employers from requiring applicants, as a condition of employment, to submit to a test for the presence of THC. In essence, this bars pre-employment drug testing for marijuana. However, there are exceptions, as usual. Employers are permitted to test for marijuana for certain positions, generally those involving safety, driving, and the care of children or other vulnerable persons. Those who occupy positions paid for by federal grants or who receive financial benefits where drug testing is required can also be tested. If a collective bargaining agreement addresses pre-employment drug testing, an employer may also be allowed to test for marijuana before hire. An important note that this law right now only applies to pre-employment drug testing. It does not cover drug testing for current employees, including post-accident, random, or reasonable suspicion. Nevada also has provided protection for applicants. By passing Assembly Bill 132, which is effective on January 1st, 2020, Nevada is the first state to protect applicants with positive marijuana drug test results. The law prohibits employers from refusing to hire job applicants who test positive for marijuana. There are some exceptions, including firefighter and EMT positions, jobs requiring the operation of a motor vehicle, if federal or state law require testing, and positions that employers determine could adversely affect the safety of others. Another portion of the law is pretty interesting. If an employer requires a new employee to take a drug test within the first 30 days of employment and that employee tests positive for marijuana, the employee can submit to a new drug test in order to rebut the results of the original test. The employee must pay for this new test, but the employer must accept and at least consider the new results. Nevada also passed the Nevada Second Chance Act, effective as of July 1st. It permits a person to petition the court to seal criminal records tied to any offense that has been decriminalized, including low-level marijuana convictions. So the question now is, where are we going in terms of pending legislation? And will there ever be a federal law that legalizes marijuana in some way? There are over 10 states that are considering bills that would provide protection to employees who use marijuana. These include general protections similar to what I've already discussed, and the bills may also place limitations on employers as to when they can test for marijuana and how they can discipline employees. Congress is also considering marijuana legislation. H.R. 3884 is known as the Marijuana Opportunity Reinvestment and Expungement Act, or the MORE Act, because lawmakers love acronyms. The legislation is currently being considered by Congress and would decriminalize cannabis. It would also deschedule cannabis by removing it completely from the drug schedules. It would provide relief for those who have been adversely impacted by the war on drugs and lead to the expungement of certain cannabis offenses. In addition to the new marijuana legislation that is passed, the courts and jurisdictions with legalized marijuana have been busy clarifying the rights of marijuana users. In Whitmire v. Walmart, the Arizona plaintiff was required to take a drug test after she was involved in an accident at work. The result was positive for marijuana, and she was terminated by Walmart even though she legally used her medical marijuana prescription. The plaintiff's marijuana levels were at the highest level that could be detected by the urine drug test. Walmart argued that the plaintiff's position was safety sensitive and that she had violated its drug policy that prohibits employees from working under the influence. Ms. Whitmire claimed discrimination under the Arizona Medical Marijuana Act, which prohibits discrimination in hiring, termination, or other terms and conditions in employment based on a positive drug test for marijuana. An exception exists if the employee used, possessed, or was impaired by marijuana at work. The court held for Ms. Whitmire. holding that the high levels of marijuana in her drug test was insufficient to show that an employee was impaired while at work. A New Jersey court discussed reasonable accommodation in Wild v. Carriage Funeral Holdings. The employee, who was a funeral services director for Carriage Funeral Holdings, was involved in an accident while he was working. The accident was not his fault, and it had no connection to his legal medical cannabis use. Carriage learned about Mr. Wild's use of medical marijuana at nighttime and required him to take a drug test. The result was positive for marijuana, and Carriage terminated the plaintiff for violating its drug and alcohol policy. This court reached the opposite conclusion of the Arizona court and dismissed Mr. Wild's case, finding that New Jersey's Compassionate Use of Medical Marijuana Act does not contain employment protections for marijuana users. Employers are also not required to make accommodations under CUMA. A New Jersey court also heard the case of Mr. Cotto, a forklift driver who worked for Ardo Glass Packing. The plaintiff was disabled and used medical marijuana to treat his disability, even providing a doctor's note stating that he could operate machinery safely while using his prescription. The employee was involved in a forklift accident and was required to submit to a return to work drug test, which was positive for marijuana and led to his termination. Mr. Cotto claimed that his employer violated both CUMA and disability laws, but the court disagreed. The employer was not required to accommodate Mr. Cotto's marijuana use in the workplace under either CUMA or New Jersey's disability law. Connecticut has also been reviewing marijuana and employment law. Plaintiff Caitlin Knopfsinger underwent mandatory drug testing after accepting an offer for employment. Knopfsinger disclosed during the pre-employment process that she was approved under Connecticut's Palliative Use of Marijuana Act, or PUMA, to use medical marijuana to treat her PTSD. Knopfsinger tested positive for THC, and SCC rescinded its job offer, claiming that it could not hire her due to federal law. The U.S. District Court for Connecticut reviewed the case, finding that PUMA prohibits adverse employment action against those who use medical marijuana under the Act. It also determined that even federal contractors who are trying to comply with the Federal Drug-Free Workplace Act must adhere to PUMA and allow employees to use medical marijuana. The court further clarified that the Federal Drug-Free Workplace Act does not require drug testing or prohibit a federal contractor from employing someone who uses drugs illegally outside of work. Note that I said use of illegal drugs, not just legal. Ultimately, SCC discriminated against Knopfsinger when it rescinded her job offer. In the Montana case, Carlson v. Charter Communications, LLC, the Ninth Circuit ultimately found for the employer. Lance Carlson held a medical marijuana card under the Montana Marijuana Act. He was required to take a post-accident drug test after a workplace incident and tested positive for marijuana. Charter Communications, a federal contractor, terminated him for violation of company policy, even though his legal marijuana use took place outside of work. The Ninth Circuit found that Charter Communications was permitted to have a policy against marijuana under the Federal Drug-Free Workplace Act and was not in violation of the Montana Marijuana Act. On the other hand, the Delaware Superior Court found the opposite in Chance v. Kraft Heinz Foods Company. The plaintiff obtained a medical marijuana card due to several medical issues. He was sent for a post-accident drug test after a shuttle wagon he was operating derailed. There were issues with his first test, but he ultimately tested positive for marijuana on a test taken several days later and was ultimately terminated. The court confirmed that Delaware's Medical Marijuana Act protects medical marijuana users, and the Federal Controlled Substances Act does not preempt it. Delaware also expressly prohibits the adverse employment action against employees who use medical marijuana outside of work and then test positive on a job-related drug test. There is an exception where there is evidence that the employee used, possessed, or was impaired by marijuana while working. As you can see from the various cases we've reviewed, the states are still very much in conflict with how to treat legal marijuana use and various employment issues. So up to this point, we've discussed various marijuana legislation and court cases. So how do these laws and decisions impact employers, and what are some issues that they face? In general, employers can still drug test in many of the jurisdictions that have legalized marijuana in some way, but it's not a black and white answer across all jurisdictions, as we will see with New York City and Nevada. At this time, no state prohibits employers from discharging an employee who is under the influence of marijuana while working. However, as we have seen, there is an emerging trend of states prohibiting discrimination against employees who use marijuana outside of work to treat a medical condition. Accommodation of marijuana use is also an issue for employers. In addition to whether an employer can drug test for marijuana, an employer must also consider how it can test for current usage of marijuana, and may even need to consider how CBD and different levels of THC may impact its drug testing programs. Marijuana decriminalization can also affect an employer's background screening program. Proving impairment by marijuana in a specific moment is very problematic for employers. First, remember that the ingredient in cannabis that causes the user to feel high by causing an altered mental state is THC. It is THC that is causing issues with drug testing because we currently do not have an accurate way to test someone's level of THC intoxication. Marijuana testing differs from alcohol testing. An alcohol test can show if a person is currently intoxicated by alcohol. However, it is not possible to test to determine if a person is currently under the influence of marijuana. A positive marijuana test could show marijuana that was ingested days or weeks ago, maybe even up to 90 days depending on that specific person. The method of testing can also detect different time frames, with hair and urine detecting marijuana for longer periods of time, and oral fluids or blood providing a more recent window. Because of this, a positive marijuana drug test result is not a good indicator of whether someone is intoxicated due to marijuana use in that specific moment. Because there is no accurate test, an applicant or employee can use marijuana legally but still have a positive drug test result. While there is no clear answer as to how employers should approach this issue, it's recommended to treat applicants and employees in the same way, taking into consideration any applicable state or local laws relating to marijuana use. You may also consider having procedures for demonstrating observations of impairment, such as an employee's speech, physical dexterity, agility, coordination, demeanor, and rational or irrational or unusual behavior. It can easily change in the future, but currently all states permit employers to create and enforce drug-free workplace policies. This includes disciplining or terminating an employee if he or she is impaired on the job, whether or not the drug is legal, or if the use creates a safety risk. Because this area is changing so quickly, though, I recommend reviewing case rulings and laws that apply to your specific situation to see if you can refuse to hire applicants or terminate employees who use marijuana off the clock. The same review should be given to your local laws to determine if you're required to accommodate medical marijuana users who use medical marijuana outside of work due to a disability or a medical condition. It's also really important to address CBD and its impact on employers and drug testing. The 2018 federal farm bill legalized hemp production across the country, which removed hemp from the definition of marijuana under the Federal Controlled Substances Act and basically descheduled low THC containing hemp products. Over 20 hemp laws have also passed so far in 2019. CBD can be created from hemp and has levels of THC below 0.3%. Keep in mind, though, that it is possible for employees who use hemp-based CBD oil to test positive for THC, even though it does not cause intoxication. The purpose or the production of CBD oil is not well regulated by the FDA, so some CBD oils may contain more THC than others, and the user may not be aware of that. The drug test will detect any level of THC. It will not provide the specific level of THC, resulting only in a positive. Again, this tracks back to the lack of a test that measures not only current intoxication by marijuana, but also a test that measures specific levels of THC. I recently read about an issue in Ohio where THC below a certain level is permitted. At the end of July, Ohio legalized hemp and hemp-derived CBD. However, the issue is that Ohio's crime labs cannot currently determine the specific level of THC and can only determine whether or not THC is present. Because of this, prosecutors in Ohio are running into issues proving whether defendants have used products derived from legal hemp or if they've actually consumed illegal marijuana. Because of the issue of proof, marijuana has essentially been legalized in Ohio until crime labs are able to determine the actual levels of THC in a sample. While they are working on such a method to determine the actual levels of THC, it may be a few months before it's ready. While this doesn't directly affect an employer's drug screening program, keep in mind that your background screening program may be impacted by the decriminalization of marijuana. In jurisdictions like Hawaii, New York, and North Dakota, lower level marijuana offenses are no longer considered criminal, as we discussed earlier. Because they are no longer criminal, future lower level offenses may not show up on a criminal background check. Former marijuana offenders may also be eligible to have their prior records expunged, which can also impact your program, especially where you rescreen the same applicant or employee. As views towards marijuana continue to change and impact employers, AccuSource is happy to recommend some best practices. First, and possibly most importantly, be aware of new marijuana legislation as well as court decisions that provide guidance on drug testing and employment practices related to marijuana. Understand how marijuana is treated in the jurisdictions in which you operate. Be especially careful if you have employees who work in different jurisdictions than your home office. For example, an employee who works in New York City, but your office is located in California. Know how state and local laws coexist or conflict with federal laws, including the Federal Drug-Free Workplace Act. Make sure you review any exceptions to marijuana laws, such as DOT-covered employees or those who work in safety-sensitive positions. Speaking of safety sensitive, revisit your job descriptions and the actual duties to determine if they qualify as safety sensitive and make sure you're ready to support your argument that they are. Get your policies and procedures in order and make sure that applicants and employees understand them, especially those related to drug testing and accommodation. Also, train your supervisors and managers. Make sure they are trained to recognize and document impairment, especially in jurisdictions where a positive marijuana drug test alone is not enough to take action. While some employers may be dropping marijuana from their drug testing panels, consider waiting to do so if you are able. If applicants or employees know that you do not test for marijuana, it may result in more intoxication in the workplace. Finally, check with us with AccuSource. As soon as I come across marijuana updates, I typically post information about them to our compliance blog. And honestly, it seems like half of what I talk about lately is marijuana, so definitely keep posted with us. We've reached the end of this presentation, and I will now answer questions that we received.
Thank you, Jennifer. Now we will dedicate the remainder of the webinar to addressing attendee questions. If you have not had a chance to ask a question via our chat box, please feel free to do so now.
Thanks, Heidi. The first question that we have for you, Jennifer, is if an employee is termed for refusal to test, should that be treated as the same as a positive drug test?
Um, so in general, as long as you have refusal to test in your policy and make it very clear that refusal to test will result in termination, it can be treated the same way as a positive drug test results. I mean, ultimately, you're going to terminate that person, but it is slightly different since they're not actually doing the drug test, if that makes sense. And if you need further clarification, I can definitely provide that after the fact.
Fantastic. The next question, how should we proceed if an employee is informed that they have been randomly selected for testing and the employee admits to marijuana usage? Should they be termed or sent for testing first?
You should definitely send them for the test, because even though it gets a little bit difficult because there's so many different laws in different jurisdictions, so just because their use might be illegal or you might have a zero tolerance policy, you really need to check the laws before you terminate. And if you terminate based on what they said, even though they admitted to the use, it's definitely good to have that positive result. But again, you're going to want to check with your legal counsel and with the laws that affect your jurisdiction before you really make a decision.
Fantastic. The next question. My corporate headquarters is based in a state where marijuana is legal. But if I have multiple offices throughout the nation, some where marijuana is legal and some where marijuana is not legal, should candidates residing in non-legal marijuana states continue to be tested for marijuana if candidates who are residing in illegal marijuana states are not currently being tested for marijuana? Or should all testing be consistent for all candidates, regardless of what state they are located in?
That is completely up to you, and you should definitely discuss that with your either in-house counsel or outside counsel if you need to deal with someone who deals with drug testing laws on a daily basis. Um, the thing is, it might be consistent and uniform to remove marijuana from all of your drug testing panels, and it might make your life easier. But if you are allowed to test for it in different jurisdictions where it's illegal, if you don't test for it, it could result in people actually deciding to use marijuana. Again, you really need to check the laws to see what you can and cannot do, but it should generally be up to you as long as you're following the law.
Great. The next question that we have is, so positive THC results in Ohio are quote unquote forgiven?
They're not really forgiven per se. So, um, generally, I don't talk about specific state laws, but I was very interested in this one, and I'm just going to kind of talk about what I read in the news article that I saw. Um, so, the issue that prosecutors are facing is that the low level THC product, hemp CBD oil, that is allowed. It's legal now in Ohio. The issue is that if it's above the 0.3%, that's illegal marijuana. The problem is if someone's arrested for using marijuana and they have a positive drug test, the prosecutor can't prove definitively whether or not they were using the legal hemp product or the illegal marijuana product. So while marijuana is not officially legalized in Ohio, in essence, it kind of is because until they come up with a test to determine the actual amount of THC in your system, they can't prove it. So, yeah, you might be arrested, but they're going to have to dismiss the case, at least based on the opinion that I read, which I found very interesting.
Great. The next question is if your home office state is different from your employee's state, which state do you follow for laws?
You should definitely follow the state where the employee lives and works. So, for example, I was discussing earlier, if a home office is in California, where pre-employment drug testing isn't an issue for marijuana, but your applicant or employee lives in New York City and works in New York City, you definitely need to be aware of that ban against pre-employment drug testing for marijuana. So yes, absolutely follow the law where the person lives.
Is there a common definition of the term quote unquote impairment for marijuana use?
I haven't really come across a very specific definition. Anytime I've seen impairment, it just provides examples of what impairment signs could be. Plus, each person can be different. Some of the big ones for marijuana are bloodshot eyes. The person might talk a lot faster than usual, be more animated while talking. But then on the other hand, after they've had it in their system for a while, they could be sleepy. So it really just depends, and it's important to define those baseline impairment symptoms that you're using in your procedure, and make sure that all of your supervisors and managers are aware of them.
Okay. The next one is, where does Puerto Rico and the U.S. Virgin Islands stand on this?
So I need to take a look at that more closely, since I didn't discuss those specifically, but I can definitely get back to you after the webinar with an email response.
Okay. What are Texas laws regarding medical and decriminalization?
Unfortunately, the same exact answer. I need to look into that more closely because Texas hasn't really done anything recently, so it wasn't the focus of this webinar, but I will absolutely look into that and get back to you.
Okay. In states where medical use is permitted, are there requirements for employees to notify the employer of their approval for medicinal use if it wasn't declared or effective at the time of hire?
That's really going to depend on the state itself. And it's the same way with other types of prescription drugs like opioids. Some states require the employee to let the employer know about that. Some company policies require it, but in case you haven't really noticed, privacy is a huge issue right now, not only in the United States, but around the world. So, requiring an applicant or employee to disclose their legal prescribed medical use could potentially become a privacy issue. So, if you have any doubts or questions whatsoever, always check with your counsel. They can look into it and the specific laws that impact your company and let you know whether or not you need to require or even are permitted to require them to disclose that.
Okay. As we're almost at the end of our time, Jennifer, this will be the final live question. Again, attendees, if you've entered a question into the chat box and we did not have the opportunity to address it live, our team will follow up with you directly post-webinar to provide you with an answer. The last question for you, Jennifer, is if we suspect that an employee is under the influence, do you allow them to drive themselves to the testing facility?
So it's been a few years since I was on the employer side of drug screening, but it used to be our practice to not have them drive themselves because they could potentially get into an accident or cause another issue that we were concerned about liability for. So, in the case where you have a reasonable suspicion drug test or even an accident, you should have a supervisor or manager drive them to the drug testing location, just to avoid any potential issues.
Thank you, Jennifer, for facilitating this informative webinar, and special thanks to our attendees for joining us today. Your HRCI and SHRM credits will be emailed to you within the next few days. To recap, a link to a recording of this presentation will be sent to each attendee within 24 hours. Please also feel free to visit the resource section of our website at www.accusource-online.com, where you will find our full webinar library as well as other valuable compliance and educational resources. If you have any additional questions, please contact us at marketing@accusource-online.com. On behalf of the AccuSource team, we wish you all an enjoyable day.